Good morning, everybody. I'm sure, as you're all aware by this point, the state of Illinois decided to pass their assault weapons ban last week, and it was signed into law as of, what was that, January 11th?
I believe so.
8:28 p.m. With doing so, that banned the future sale of what they classify as assault weapons and high-capacity magazines. We're going to go through what part of the bill says and what they classify as an assault weapon. We also have a little bit of case law that could potentially apply to this case that we've looked up ourselves. I'm going to link the text to the actual bill in the description, though, if you would like to read the full text. It's about 111 pages, so we're not going to try and cover everything in this video. We're going to try and keep it as brief as possible, and probably have a little bit of discussion toward the end. I just want to specify that neither Lewis nor myself are constitutional scholars, nor are we attorneys. So please do not take anything that we may say or imply as concrete. And we are not asking for a call to arms by any way, shape, or form. We're just asking for a call to action. What we mean by that is you guys should be writing letters, writing emails, making phone calls as often as possible to your local politicians, to your state congresspeople, and tell them if you think this is unjust and unconstitutional that it needs to be repealed. We need to flood them with traffic, make them do their jobs. That being said, I'm going to hand it over to Lewis and let him start reading through part of this bill.
The actual definitions of assault weapon and attachments starts on page roughly 84 of this bill and goes from there. I'm going to start with the definitions of assault weapon. That means any of the following except as provided in subdivision 2 of the subsection. A semi-automatic rifle that has the capacity to accept a detachable magazine or that may be readily modified to accept a detachable magazine if the firearm has one or more of the following. A pistol grip or thumb hole stock. Any feature capable of functioning as a protruding grip that can be held by the non-trigger hand. A folding, telescoping, thumb hole, or detachable stock, or a stock that is otherwise foldable or adjustable in a manner that operates to reduce the length, size, or any other dimension, or otherwise enhances the concealability of the weapon, as well as includes a flash suppressor, a grenade launcher, a shroud attached to the barrel or that partially or completely encircles the barrel, allowing the bearer to hold the firearm with the non-trigger hand without being burned, but excluding a slide that encloses the barrel. A semi-automatic rifle that has a fixed magazine with the capacity to accept more than 10 rounds, except for an attached tubular device designed to accept and capable of operating only with .22 caliber rimfire ammunition. So the assault weapons ban by the text includes rifles that can accept detachable magazines over 10 rounds with these banned features. So it would include your ARs, your AKs, etc.
And they do have a list in this bill, it's quite long, of specific firearms and brands of firearms that they included in this ban. Like I said, we will list a link to the General Assembly website where you can read the full text of this bill, just because the information included in it is too numerous to include in one video. I'm trying to keep this relatively brief. You done?
Yeah, I just want to reiterate that a lot of this also is similar to the California assault weapons ban that bans certain features. This just takes it a step further.
At this time, I'm going to talk about case law, Supreme Court case law that could potentially apply to this. I would advise you guys to get a piece of paper and an ink pen and at least write these cases down and do some research for yourself so you can read through every bit of what is contained in these. I just have a brief summary of some of these. 2008, the District of Columbia versus Heller, 554 U.S. 570, is a decision of the U.S. Supreme Court ruling that the Second Amendment to the U.S. Constitution protects an individual's right to keep and bear arms, unconnected with service in a militia, for traditionally lawful purposes, such as self-defense within the home, that the District of Columbia's handgun ban and requirement that lawfully owned rifles and shotguns be kept unloaded and disassembled or bound by a trigger lock violated this guarantee. It was a Supreme Court case to decide whether the Second Amendment protects an individual right to keep and bear arms for self-defense, or whether the right was only intended for state militias. On June 26, 2008, the Supreme Court struck down provisions of the Firearms Control Regulations Act of 1975 as unconstitutional, determined that handguns are arms for purpose of the Second Amendment, found that the Regulations Act was an unconstitutional ban, and struck down the portion of the Regulations Act that requires all firearms, including rifles and shotguns, be kept unloaded and disassembled or bound by a trigger lock. Prior to this decision, the Firearms Control Regulation Act of 1975 also restricted residents from owning handguns except for those registered prior to 1975. That's the key information right there. The Supreme Court held that, number one, the Second Amendment protects an individual right to possess a firearm unconnected with service in the militia and to use that arm for traditionally lawful purposes, such as self-defense within the home. That the amendment's prefatory clause announces a purpose but does not limit or expand the scope of the second part, the operative clause. The operative clause's text and history demonstrate that it connotes a individual right to keep and bear arms. The prefatory clause comports with the court's interpretation of the operative clause. The militia comprised all males physically capable of acting in concert for the common defense. The Anti-Federalists feared that the federal government would disarm the people in order to disable the citizens' militia, enabling a politicized standing army or a select militia to rule. The response was to deny Congress power to abridge the ancient right of individuals to keep and bear arms, so that the ideal of a citizens' militia would be preserved. The court's interpretation is confirmed by an analogous arms-bearing rights and state constitutions that preceded and immediately followed the Second Amendment. The Second Amendment's drafting history, while of dubious interpretive worth, reveals 3 state Second Amendment proposals that unequivocally referred to an individual right to bear arms. Interpretation of the Second Amendment by scholars, courts, and legislators from immediately after its ratification through the late 19th century also support the court's conclusion. The district's total ban on handgun possession in the home amounts to a prohibition on an entire class of arms that Americans overwhelmingly choose for the lawful purpose of self-defense. Under any of the standards of scrutiny, the court has applied to enumerated constitutional rights this prohibition. In the place where the importance of the lawful defense of self, family, and property is most acute, would fail constitutional muster. The Illinois Supreme Court, in People v. Aguilar, 2013, summed up the Heller findings in reasoning that the court ultimately concluded the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation, that central to this right is the inherent right of self-defense, that the home is where the need for defense of the self, family, and property is most acute, and that above all other interests, the Second Amendment elevates the right of law-abiding, responsible citizens to use arms in defense of hearth and home. Based on this understanding, the court held that a District of Columbia law banning handgun possession in the home is violating the Second Amendment. That being said, yes, we have concealed carry now, but they're trying to limit common defense firearms that you can buy and carry. In MacDonald versus the City of Chicago, 2010, it's 561 U.S. 742. The court ruled that the Second Amendment was incorporated against state and local governments through the Due Process Clause of the 14th Amendment. Now, this is a very key case here as well. In the decision, the court said, in Heller, we held that the Second Amendment protects the right to possess a handgun in the home for the purpose of self-defense, unless considerations of state decisis counsel otherwise. A provision of the Bill of Rights that protects a right that is fundamental from an American perspective applies equally to the federal government and the states. That is a very key piece of information. When people often refer to the Second Amendment portion that says shall not be infringed, initially the Supreme Court ruled that that only applied to Congress. Well, according to the Supreme Court ruling in MacDonald versus Chicago, that applies to the federal government as well as state governments under the 14th Amendment. We therefore hold that the Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller. As far as specific firearms that they're attempting to ban, if you look at Caetano versus Massachusetts, number 14-10078, 577 U.S. from 2016, the court ruled that the Second Amendment extends to all forms of bearable arms. The court has held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, and that Second Amendment right is fully applicable to the states. Most recent is the New York State Rifle and Pistol Association Incorporated versus Bruen 597 U.S. from 2022. The case's decision was released on June 23, 2022. The court held that the state law was unconstitutional as it infringed on the right to keep and bear arms, reversing the Second Circuit's decision and remanding the case for further review. This effectively rendered public carry a constitutional right under the Second Amendment. The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. When the Second Amendment's plain text covers an individual's conduct, the right to bear arms, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of the Second Amendment's unqualified command. Nothing, in our opinion, should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Our holding decides nothing about who may lawfully possess a firearm or the requirements that must be met to buy a gun. They also questioned whether a person bent on committing an atrocity, such as a mass shooting, would be deterred because it would be illegal for him to carry a firearm outside of his home. Justice Alito further pointed out that the recent shooting rampage in Buffalo that occurred in New York and New York's law had done nothing to stop the perpetrator. So that being said, I don't know what atrocities they think they're going to stop by banning certain types of firearms based on physical features or based on how much ammunition they can hold. This is the opinion part of the video, mind you. I truly believe that if somebody wants to cause somebody else or a group of people a form of great bodily harm, they're going to do whatever they have to achieve that. I mean, there's assaults that happen with hammers. There's assaults that happen with 2x4s, common construction tools and materials.
All this is really going to do is limit law-abiding citizens. It's not going to stop a criminal.
It's really not. Like I mentioned earlier, though, I implore you guys to please look up those cases and read the text regarding those. That was just a brief summarization of what I felt applied to what we're dealing with now. You want to go through the counties?
In one moment, I'll get to that. So we described the features of rifles that are banned, and that's primarily what this targets, but also has language to include handguns as well as shotguns. Semi-automatic pistols that have the capacity to accept detachable magazines are classified as assault weapons. They have one or more of the following features: threaded barrels, a second pistol grip or another feature capable of functioning as a grip, a shroud attached to the barrel or that partially encircles a barrel, allowing the bearer to hold the firearm with a non-trigger hand without being burned, excluding a slide that encloses the barrel. Banned features also include for handguns flash hiders, buffer tubes or arm braces, as well as magazines that hold more than 15 rounds. So full-size magazines like your Glock 17 that holds 17 rounds, those would be banned, but not the Glock 19, which holds 15.
I really think that falls back under the Caetano versus Massachusetts case, where all forms of bearable arms are covered under the Second Amendment.
Shotguns with revolving cylinders are also included as assault weapons.
Any shotgun with a revolving cylinder.
As well as semi-automatic shotguns that have one or more of the following features: pistol grips, any feature capable of functioning as a protruding grip held by the non-trigger hand, folding or thumb hole stocks, grenade launchers. I'd hate if I had to give up my shotgun grenade launchers. Or fixed magazines with a capacity of more than 5 rounds, or the capacity to accept detachable magazines. So as far as shotgun goes, from this language, pump actions are good to go still, right?
As long as they don't have a detachable magazine.
Correct. Or a revolving cylinder.
Yeah, or a
Because those are
cylinder.
very, very, very common.
Yes.
This bill also bans semi-automatic firearms as a capacity to accept belt ammunition feeding devices. So anyone that has, those semi-auto 240s.
Yeah, if you went and dropped, $7,000 or $8,000 on a semi-automatic FN, you can't have that anymore. Because we all commonly walk around with belt-fed weapons.
I mean, in a perfect world.
Yeah.
This also bans any part or combination of parts designed or intended to convert a firearm into an assault weapon, including any combination of parts from which an assault weapon may be readily assembled if those parts are in the possession or under the control of the same person. So, by this language, it sounds like parts kits would also be affected, correct?
I don't know. I've not interpreted that part of the bill. That's something to leave up to the attorneys to decide.
Mm-hmm.
When you guys look up this bill, it amended several other things that were already signed into law.
Mm-hmm.
The new language and the new additions are all underlined and in bold text, so they're easy to spot. But we tried to comb through this yesterday, and the language they use is just kind of mind-boggling. It's incredibly redundant and repetitive. So we're just trying to pull out the gist of what really is going to affect people as this new bill has passed.
Mm. And then it gets into the list of specific banned firearms, which is 3, 4, 5, 6 pages.
As far as the registration requirement, from my understanding, because I know some people have talked about, they heard it was 300 days, some heard it was 90 days. From my understanding, I could be wrong on this, but from what I've read, the 300 days was how long they have to get the system set up. And I think the date that they've released on that was October 1st. From the time that is set up and functioning, the 90-day period was when you had to actually register the firearms, which was January 1st of 2024 was the deadline for that. So I'm not going to tell anybody not to comply with the law because that would be reckless and irresponsible. But I'm going to tell you to do what you believe in.
Mm.
And I think Lewis and I pretty well agree and stand on the same ground as far as that's concerned.
Mm.
Is there anything else you want to talk about?
As far as current events in the state, many county sheriffs have released statements.
The majority of county sheriffs.
Stating that they will either not enforce or they support the Second Amendment, at least until this goes to court and is settled by a judge.
Yes, that's another key thing there. A lot of these sheriffs have stated that they will not house people solely based on violation of that law unless a judge tells them they have to. If a judge says that you have to go to jail, they're going to take you to jail. So that part was not really highlighted when all those statements come out. So I appreciate the sheriffs and the state's attorneys, that have come out and made those statements. That being said,
take it with a grain of salt.
Take it with a grain of salt.
Mm-hmm.
I would not rely on that actually happening because things could change. There's a lot of time between now and whenever the registration requirement is supposed to take effect. So things could definitely change.
And as of the time of this video, 3 counties have came out saying they will in fact enforce this bill. Those counties are Lake County, Cook County, and Champaign. 4 counties have not released a statement, which would be Alexander, Jackson, Morgan, and Warren. Every other county in the state has released a statement against the bill or in favor of the Second Amendment. Various states' attorneys have said they will use discretion in prosecuting cases based around this bill. So, like I said, take it with a grain of salt. I wouldn't consider this concrete or that local law enforcement is going to be your friend if you violate anything in this bill.
Guys, I just want to reiterate, neither of us are constitutional scholars, nor are we attorneys, nor are we calling for any sort of armed action. We want people to contact their congressmen, congresswomen, emails, letters, phone calls, as much as you possibly can. I mean, flood them. Make them do their jobs as much as you possibly can.
And if you are an FFL that's threatening to be put out of business,
you should absolutely consult with an attorney. And if it's directly affected your business and your income for you and your family, I would definitely, if it were me, I would definitely consult an attorney, and I would be filing a lawsuit because he is going to put a lot of good men and women out of business.
I
with this
believe
law.
the organization that's going to be filing on that, like I said, I believe, is the Federal Firearms Licensees of Illinois, FFL-IL. We're the ones to get in contact with if you're an FFL dealer.
As of the recording of this video, we're not aware of any federal lawsuits that have been filed yet, but we've heard a lot of rumor about, I know the State Rifle Association had said last week they planned on filing a federal lawsuit as early as today. We will try to keep up on this and post updates as we can. As far as we're concerned, nothing changes with our channel. We're going to keep doing our thing, making more videos. We greatly appreciate everyone that took the time to watch this entire video. I know it's very lengthy and it's very dry, but it's information that we felt you guys needed to know and would want to know. Is there anything else you need to add, Lewis?
I don't believe so at this time.
Guys, if you thought this video was helpful, please share it. Share it with everybody, not just people that live in Illinois. There are 8 other states that have bans in place similar to what we're going through right now. I wholeheartedly hope that people watch this or watch something or just decide on their own even to contact their congresspeople and get them repealed, because it's a slippery slope. It started with 1, and then it was 2, and then it was 8, and now we're number 9.
And if you think this bill is the end, this is, they get what they want, you're wrong, because they're going to be coming for something else next round, next year.
You give them an inch, they take a mile. So we're not calling for armed action in any way, but this is a call to action. Now is the time to do this and make these people do their jobs. And when election time comes around, get them out of office. They do not care about you. They don't care about anything but themselves and their money. Oh, and I think it's also kind of off topic, but didn't you tell me that Illinois Congress voted to give themselves an 18% raise while telling you what you can and can't own in your own home and what you can and can't buy?
They take your rights, raise your taxes, and vote themselves raises.
Don't you love it?
Fantastic.
That is exactly why we can't let them infringe on the Second Amendment. But guys, we appreciate you watching this video. Like I said, please share this with everybody. Even if you don't want to watch it, man, just put some headphones in and tell them put headphones in and set it to the side. We're not doing anything on camera they need to watch anyway. We're just talking. But subscribe if you'd like to see more content from us in the future. As I said, we will try to post regular updates as more information becomes aware to us. If we said something that is wrong, please leave me a comment down below and let us know. We will definitely correct that if that was the case. Other than that, I appreciate you guys watching. Give us a thumbs up, and we hope to see you guys in the next one. Thank you.